Derek Mendes Da Costa is our next speaker, who is going to share with us his glimpse into the crystal ball as to the future of enforcement of judgments and orders. Derek is the chairman of the Ontario Law Reform Commission, as you know. He has not one, but he has two doctorates in law from Harvard and from London. He has lectured at such diverse places at University of Melbourne, Arizona, University of Texas, University of London, and University of Toronto. I would be here a long time if I were to do justice to his qualifications, which fill 5 pages, single-spaced. Suffice it to say that he is an extremely erudite gentleman and one who has been quoted authoritatively in judgment after judgment, even though he is not yet dead, which is quite an achievement. Derek, I was with Derek, had the privilege of being with Derek on a federal conference this summer, the Uniform Law Conference, and I can tell you from first-hand observation of the immense respect and the affection with which he's held by the law reform people, the legislators from coast to coast of this country. We're very fortunate to have him here today.
Mr. Doran, sir, thank you very much indeed. You said, I think, not yet dead, and I stood there wondering, yes, I guess that's true, but some people have said it's hard to tell. Thank you very much for your kind introduction. In fact, if you forgive me, let me take just 1 second to tell you a story that came to my mind while Burke was talking. It was the story of the Human Cannonball. Have you heard the story of the Human Cannonball? For 20 years, he was a human cannonball. And in the morning at 11 and in the afternoon at 3:30, day after day, Saturdays and Sundays, into the cannon he'd go, shot across the ring into the safety net. He went on and on for 20 years. And finally, he came to the manager of this affair, this circus, and said, I quit. And the manager said, you quit? He said, I quit for 20 years. 11, 3:30, into the cannon, shot across the ring. And the manager said to him, I'm very sorry to hear that. He said, men of your caliber are hard to find. And Burke, you can draw what inference you wish. Now, my very great pleasure to be here, and the schedule is I end at 12:15. So I want to thank you very much for this opportunity. But what I will do, I cannot promise to end at 12:15, but I hate to see people seeping out the exit doors, and I know that some of you may have engagements, so what I will say is I will try to be as brief as I can. I will not go the allotted time, I think, but I will try to be brief. For some time, the Ontario Law Reform Commission has been engaged in a detailed study of the substantive and procedural rules and the actual practice relating to the enforcement of money judgments. The project presented a very powerful challenge to the Commission. It became apparent at a very early stage of our research that in the history of the province there had not been any comprehensive survey of this law area. The result, at best, was patchy and uneven development that had occurred on an ad hoc basis, responding to whatever pressures from time to time may have existed. In addition, we found that in some areas of the law, there were controlling principles, statutory and common law, inherited quite literally from medieval England. The project is near completion. Because of the size and the complexity of the project, the Commission has decided to present its report in 5 separate parts that will comprise, in total, approximately 1,250 pages. We hope that the first 3 parts will be available within the next little while. But at the moment, let me tell you that the reports are not yet completed and, of course, have not yet been tabled in the legislature. But to give you some idea of the sweep of the project, briefly indicate to you the topics with which we've dealt. And I'll deal with the report, as I will in my later comments, part by part. Part 1, 3 main matters: an orderly payment of debt scheme modeled on the proposed new Bankruptcy Act, Bill C-12. Secondly, the structure and organization of the enforcement system. And thirdly, methods of obtaining information from and concerning debtors. Part 2 of the report will survey all methods of enforcement of a money judgment against personal property and will include the seizure and sale of personal property, garnishment of income and other debts, equitable execution, charging orders, stop orders, interpleader proceedings. Part 3 will deal with enforcement against land and will be concerned with both procedural and substantive issues. Part 4 of the report will canvass, 2 main areas: the law relating to voidable transactions, the Fraudulent Conveyances Act, and the Assignment and Preferences Act, and secondly, prejudgment remedies. The last part, Part 5, will deal with the distribution of the proceeds of enforcement, the Creditors Relief Act, with the liability of the sheriff, and with some miscellaneous matters. Now, as I mentioned, our reports have not yet been completed. None have been tabled in the legislature, and I cannot at this stage share with you any of our recommendations. But what I want to do is to indicate to you some of the problem areas, some of the problems that raised questions of policy that the Commission had to decide. I would like to emphasize that because I mention a law area doesn't necessarily mean that we recommend change, doesn't obviously indicate the way in which we recommend the change to occur. Now, I think it's a difficult task. It's one thing, I think, to talk about this law area. You can structure your talk and hopefully present it as a rational whole, but in a short time to sketch a project of this magnitude is difficult. And what I have done is to take each part, 1 to 5, isolate a few topics and problems that we faced, and tell you what they were. It's also not easy because I've heard it said, and I'm sure it's been said in this session, that there has been enough change in the law in recent times to last for a while. And the profession tends to be, I think, a little unsympathetic to yet another massive report recommending dramatic changes in an important law area that has practical implications. Nevertheless, let me start and deal with part 1 of the report. The topic I've selected here is structural and concerns the nature of the present enforcement system. And I'll say a few words. In Ontario today, a money judgment may be obtained from 5 different courts: the Supreme Court, the county and district courts, small claims court, provincial court family division, the Unified Family Court. And as you know, in metropolitan Toronto, since July 1, 1980, the Provincial Court Civil Division, on an experimental basis, has been functioning in place of the Small Claims Court. Now, although a separate superstructure does not exist for each of these courts, to some extent, the enforcement of judgments from these courts is handled by different officials. For example, Supreme Court and the county and district courts, well, judgments, the enforcement of money judgments, in the main is the responsibility of the sheriff. And certainly sheriffs are the main actors in the seizure and sale of the debtor's property. On the other hand, garnishment of debts owed to a Supreme Court or a county or district court judgment debtor is a matter for the courts, and the sheriffs are only peripherally involved. Now, contrast that with the Small Claims Court. Case of money judgments, the responsibility for seizure and sale of the debtor's property is in the bailiff of the Small Claims Court rather than the sheriff. And on the other hand, it's to the clerk of the Small Claims Court that the creditor applies for garnishment. In the Provincial Court Family Division and the Unified Family Court, there's yet another administrative regime for enforcement. As in the case of the Small Claims Court, the granting of garnishment is within the jurisdiction of the court clerk, but it's the local sheriff that is cloaked with the authority to seize and sell the property of a person against whom there is a judgment for money in the Provincial Court Family Division or the Unified Family Court. Now, at present, there's been little attempt made to coordinate the enforcement efforts emanating from these different court levels. At the Supreme Court and the county and district court levels, where the seizure and sale of a debtor's property comes under the auspices of the sheriff's office, to date, there's been little energy devoted to coordinating the activities of sheriffs throughout the province. For example, at the present time, a creditor who wishes to reach the property of his debtor found in different counties is required to file a writ of execution in the sheriff's office in each county where the debtor's property is located, and to instruct each sheriff separately on the steps that he should take to enforce the judgment. When you have mobility of population, clearly it makes the task of enforcement that much more difficult. Let me give you just two brief examples. First, you have a debtor with a number of outstanding judgments against him. Supreme Court, County Court on the one hand, Small Claims Court on the other hand. The sheriff will visit him to enforce the Supreme Court or county or district court judgment. But the bailiff of the Small Claims Court will visit him to enforce the judgment in the Small Claims Court. So in the position of the debtor, particularly if he has no exigible assets, he'll receive visits at different times from different enforcement officials. And the coordination between the sheriffs on the one hand and the bailiffs of the other hand is certainly throughout the province far from complete. Second brief example is a debtor who has been ordered to pay maintenance in the family court and has judgment, for example, in the county court. The creditors realize his only exigible asset is his income from his employer. Each creditor seeks to garnish. What is the employer to do? From one court, he gets a garnishment notice. From another court, he gets a garnishment notice. How much is he to pay the debtor? How much is he to deduct? Whatever he deducts, how is he to pay to two courts that sum? Or how does he divide it? on the present state of the law, there seems little guidance that one can give. The only exception, which is clear, is under the Family Law Reform Act, Section 30, subsection 3, which I assume has been discussed in the talk by Her Honor Judge Abella and by Tom Bastido. Well, this glimpse of the present structure raises, I think, obvious questions. First, to what extent is the present structure satisfactory? Should there be introduced into the province a new and comprehensive system responsible for the enforcement of all debts from all courts? If so, should there be any exceptions? And again, what should those exceptions be? Now, I'll turn to mention a few topics we discussed in Part 2. Part 2 of the report is really a very vast document. It canvasses, as I said, all methods of enforcement presently available in the province against personal property. And there were a great many issues for the Commission to decide. I've selected 3 separate topics. Each one I'll briefly mention: shares in private companies, garnishment, and equitable execution. First, shares in private companies. The Execution Act in Ontario has dealt with private company shares since 1929. In that year, what is now Section 15 of the Execution Act was introduced. I'll read it to you briefly. If a sheriff seizes the shares of an execution debtor in a private company, he shall first offer them for sale to the other shareholders, or any one of them in such private company. And if none of them will purchase the shares for a reasonable price, the sheriff may then offer the debtor's interest therein for sale to the public generally, and convey to the highest bidder. However, despite the language of Section 15, it's still unclear whether private company shares with the normal share transfer restrictions may be seized under Ontario law. And further, even assuming that such shares can be seized and sold, a purchaser may, because of the share transfer restrictions, be unable to obtain the registration of his shares in the company books. As a result, the shares may, in practice, be all but worthless. The questions again are obvious. Should there be a change in the law? The interests of the other shareholders in repelling the intrusion of a stranger are clear. On the other hand, the restrictions upon transfer may seriously prejudice a judgment creditor. Does the present law satisfactorily balance these potentially conflicting interests? Secondly, garnishment. Let me mention 2 points only to you. Generally speaking, debts that are due and payable, or debts that are due but payable at a future time, are now subject to garnishment. But conditional, contingent, and future debts may not, at present, be secured by a creditor. Secondly, under the present law, garnishment is a one-shot remedy. A creditor must seek a separate garnishment order for each and every debt he seeks to secure, whether or not the monies in question are paid to the debtor on a periodic basis, such as wages and salary. The recent exception is the provision contained in Section 30 of the Family Law Reform Act, which has introduced the concept of continuing garnishment. But again, the questions are clear. Should the remedy of garnishment be made available in relation to all debts? If there should be exceptions, what should they be? Secondly, should a continuing garnishment remedy, as introduced by the Family Law Reform Act, be made available to all creditors? The third topic, out of the very many canvassed in Part 2 of the report, that I selected to mention, is equitable execution. As I've indicated briefly, the law of enforcement, to a significant degree, is archaic and outmoded. A good example is the remedy that's euphemistically known as equitable execution. It's a remnant of the powers of the Court of Chancery before the fusion of law and equity by the Judicature Act. And at one time, this remedy did provide judgment creditors with relief where none otherwise existed at common law. However, today, the appointment of a receiver by way of equitable execution pursuant to the Judicature Act is of limited utility. The remedy has been very severely restricted in its scope by the case law, and in some respects, the formal usefulness of the remedy has been overtaken by legislative developments. And finally, the powers of a receiver appointed by way of equitable execution are of such a limited nature that even when the remedy has some utility, it is far from an expeditious enforcement remedy. Now, the Commission considered the future of equitable execution under a revised enforcement regime. And the Commission was called upon to decide whether the receivership function of equitable execution should be retained, and if so expanded in order to make the remedy efficacious, yet equitable. And of particular concern to the Commission were the powers to be granted to a receiver acting to enforce a judgment debt. Part 3 of the report deals, as I said, with enforcement against land. And here we were concerned with both procedural and substantive problems. Now, in September 1979, the Commission circulated this document containing tentative proposals for reform. It was circulated to all members of the real property section and the civil litigation section of the Canadian Bar Association, and to all sheriffs and masters of title and registrars throughout the province. I should say that we are deeply grateful to those people who did respond. The replies were of great assistance to us, and in some cases were influential in that the Commission did depart to some degree from some of its tentative conclusions. The main topic the Commission canvassed in this paper was the similar name problem, which we understood to be of particular concern to the profession. To state the problem briefly, when a writ is filed in the Sheriff's Office, or in the case of Land Titles Act land, when it is delivered and recorded by the Master of Titles, it operates as a kind of general lien and binds all lands of the debtor throughout the county of the sheriff and throughout the land titles division. Accordingly, there is no need for the creditor to register the writ against title to any specific land. Follows from that it's necessary for a purchaser or mortgagee not only to search title to the land, but also to search for outstanding writs. The method will vary depending whether it's Registry or Land Titles Act land. Further, in the case of Registry Act land, a search for executions must be undertaken in respect of all previous owners, as far back as a good root of title. Such a search may bring to light a number of writs of execution filed against persons with names similar to previous owners of the property, and that, as a result, may bind the land. The vendor of the property, the mortgagor of the property, will then be required to satisfy the purchaser or the mortgagee that he is not the same person as the one against whom the writ has been filed, or that his predecessor in title is not the same person as the one with a similar name against whom a writ of execution is outstanding. The need to conduct last-minute sub-searches against title to property further exacerbates the similar name problem, producing delay and expense for those who, more often than not, are in no way concerned with the debtor-creditor relationship. And so far as we can ascertain, very few judgments have been satisfied just because they have been revealed on an alienation of land. To meet this problem, the Commission has fashioned both short-term solutions and long-term solutions. There are other matters that we canvassed in Volume 3, of course, relating to land, as I said, dealing with substantive issues, but I'll pass over them at this stage and go straight to Part 4, and I will comment briefly on one matter that we canvassed in Part 4 and one matter in Part 5. Part 4 of the report, if you recall, deals with voidable transactions and prejudgment remedies. I'll mention briefly prejudgment remedies. Now, some sort of prejudgment relief has been part of the common law since the Middle Ages. Now, at that time, the prejudgment remedy available to creditors was the arrest of their debtors to ensure their presence at trial. While arrest as a prejudgment remedy has fallen into disfavor in many common law jurisdictions, it's still available in Ontario. The Fraudulent Debtors Arrest Act, I'll read again to you briefly, Section 2.1, where a person by affidavit of himself or some other person shows to the satisfaction of a judge of the Supreme Court or of a county court that he has a cause of action against the person liable to arrest to the amount of not less than $100, and also such facts and circumstances as satisfy the judge that there is a good and probable cause for believing that such person, unless he be forthwith apprehended, is about to quit Ontario with intent to defraud his creditors generally, or the applicant in particular, the judge may order that the person against whom the application is made be arrested and give security for such sum as the judge thinks fit. In addition to prejudgment arrest, now a creditor in Ontario in limited circumstances may attach his debtor's property before judgment. In this way, the creditor can guarantee that any judgment that he eventually does secure will be satisfied. The statute is the Absconding Debtors Act. The key provision is Section 2.1, which states, where a person resident in Ontario departs therefrom with intent to defraud his creditors or any of them, or to avoid being arrested or served with process, being then possessed of any real or personal property therein not exempt by law from seizure under execution, he shall be deemed an absconding debtor, and such property may be seized and taken by an order of attachment for the satisfying of his debts. Now, when you consider the language of the Act, you have to satisfy a number of conditions. First, you must show that the debtor has departed Ontario. It's not sufficient if he's about to depart. Secondly, you must show that his intention in departing was to defeat his creditors or any of them, or to avoid being arrested or served with process. You must also show that at the time of departure, he was possessed of property not exempt from seizure under execution. And also, under Section 3.1 of the Act, there's a fourth condition. The creditor must prove that the debtor was indebted to him in an amount greater than $100. And consequentially, it's unlikely that the remedy of prejudgment attachment can be resorted to by a person who seeks damages for injuries suffered as a result of another's tortious conduct. Now, it's said that there are deficiencies in the Absconding Debtors Act. How likely is it that a debtor who's left Ontario intending to defeat his creditors will leave behind exigible property that might be attached? What if the debtor, rather than departing from the jurisdiction, simply conceals himself and his property, or begins to dispose of his property with the intent described in the Absconding Debtors Act? And it's odd to note that, at least in some of these precluding circumstances, a small claims court claimant can attach his debtor's property under the absconding debtors provisions of the Small Claims Court Act. With the exception of Nova Scotia and Prince Edward Island, the legislation in the common law provinces is much the same, but recently Nova Scotia and Prince Edward Island enacted a more comprehensive prejudgment attachment remedy. I won't read these provisions to you, except simply one. Section 49.011A of the Nova Scotia Civil Procedure Rules reads, where a defendant resides out of the jurisdiction, a plaintiff may, at or after the commencement of the proceeding and before judgment, make application for an attachment. Now again, the Commission was confronted with difficult decisions. Should there be prejudgment remedies at all? Is the present position satisfactory? Does the Nova Scotia provision I just read go too far? What protection should there be afforded to debtors? Should the debtor be given notice of his creditor's application? What should be the strength of the creditor's case before he's entitled to such relief? Should the application be heard by a judge in court or be dealt with by an administrative official? How much of the debtor's property should a creditor be allowed to tie up before securing judgment? Should a debtor against whom a prejudgment attachment order has been permitted be able to provide alternative security for the creditor's claim? Should a debtor whose property has been attached wrongfully be entitled to seek damages from the attaching creditor? There were some of the questions the Commission had to resolve. Also, I would mention that the whole issue of prejudgment remedies came to the fore as a result of the development in England in 1979 of the so-called Mareva injunction. Now, the thrust of the Mareva injunction is to prevent a defendant, to seek an injunction, to prevent a defendant before judgment from taking property outside the jurisdiction or of disposing of it within the jurisdiction. And unlike the Fraudulent Debtors Arrest Act or the Absconding Debtors Act, this remedy, the Mareva injunction, may be available where the debtor is within or outside the jurisdiction. And it's a recent development, and It was recently granted, I think for the first time in this province, in a High Court decision last month of Liberty National Bank and Trust Company and AICM. For the first time, the Ontario Supreme Court granted the remedy of a Moreover injunction. There are other matters that I wanted to mention, but I won't. Because of the time, I'll simply conclude. And in conclusion, I think I'll say just this. I much welcome the opportunity to come here today. The special lecture series of the Law Society form a special part, I guess, in the life of the province. And as I say, it was a privilege to be asked to come here and to tell you of the forthcoming report of the Ontario Law Reform Commission. I hope when you receive the report, you'll have a chance to read it. Once we do report, we are functus, but nevertheless, we deeply appreciate any comments you may have. On behalf of the Commission, thank you very much, sir, for the invitation to be here this morning.
Thank you, Derek. Thank you, everybody, very much.